us, and welcome to KTA's Copyright Clinic. The theme for this year is about commercialization of intellectual property. And with us today is a diverse panel, and this is the program. We shall have opening remarks from our partner Asmahani. We shall have brief introductions of the next speaker. The other speakers will be introduced subsequently. Then we'll have a presentation by Kenneth Muhanje about the basics of copyright and what is protectable. We'll have a 15 minutes break after that. Then we'll have a presentation from an officer from the Intellectual Property Department of URSB, talking to us about how to register copyright at URSB. We'll end, the last session that we'll have will be a panel discussion, which is also the feature of our hashtag. Please, if you are sharing out there on social media, please tag us. And the hashtag is #@BatHasMyBread. This panel will be chaired by our Judith Kagere and will comprise of Brian Kajubi, who is an IP practitioner, David Tayewa, who's the Director of Publishing and Royalties Management at Voices and Beats Records, Samuel Tebandeke, who is the CEO of Kiasi Productions, and Peter Kagai, who is a poet. Without taking up so much time, let me invite Asmahani Saad to give us the opening remarks. Asmahani Saad is a partner at KTA Advocates. Ms. Asmahani, thank you.
Thank you, Benita. Thank you everyone for joining us. Good morning to you all, our distinguished participants, our invited panelists in all your respected professions and capacities, my fellow partners at KTA and our amazing team at KTA Advocates. Ladies and gentlemen, you're welcome to our first and novel copyright clinic. Like most of us have observed in this season, a lot is going on. So it is truly my utmost honor to welcome all of you to an idea that was birthed by our technology, intellectual property, media and telecom team. And this is really us living the KTA values. And this is us being bold and pragmatic and dependable. And as an innovative team, responding to the social and economic outcry, especially among the artists, creatives, and general talent in Uganda. For example, it was quoted that all Ugandan websites that upload Ugandan music do not pay money to artists. So the hashtag that followed that was that, please remove all my music from your platform. And this was a tweet by one of the most applauded musicians in Uganda, Apas Bagonza. So as lawyers and advocates, our role does not only end at interpreting the law or representing our clients in courts of law, but we have a duty to advocate for issues that will provide lasting solutions to the social and economic outcries in our society. Now, this is us at KTA Advocates impacting lives, and also using our knowledge and expertise to just share and see that we contribute positively to the growth of our economic and social environment. At KTA Advocates, we understand that every artist is entitled to different rights for their creations, and one of these is the economic right to earn from their creations. Technology is a driving force in making this possible, despite also having different platforms, social media platforms, but we also note with concern as advocates that these platforms are being abused. And like I've shared before, music is being uploaded without recognizing or even paying for that content. This abuse, we may also note, may stem from simple ignorance of our society not clearly understanding the laws and why we need to advocate for these as economic rights. But also, the best way to fight ignorance is to inform and have the knowledge shared. So we do this to ensure that the social and economic dynamic of around the creative sector, around the music sector, around talent creation and development is protected. This pandemic, not to say, has presented so many challenges, but we are also proud to share that the legal regime is not left backwards. There are a lot of strides being made to ensure that we are working together, that is the law and the social and economic dynamic of our society, to see that we have one voice. And part of this, for example, what I can share is that there are strides that are being taken to see that, and this is under the Movable Property Act, to see that we promote and leverage commercialization of copyright among intellectual property to be used to secure different kinds of securities and also be used to advance economic rights. So today we arise with this specific drive for this specific category of people and rights in society to create a movement which we have tagged hashtag @ButtersMyBread, to see that we develop a vision, a common vision, to ensure that our artists, our creatives, they are part of this movement, and they truly earn what they deserve from their creations, from their talent, and so on and so forth. So we clearly have demonstrated this by starting up these copyright clinics. This is the first of its kind. It's virtual, but believe me, we will continue with this same aspiration. So please keep updated on our social media pages, on our website, for the different copyright clinics that will run throughout the year and years to follow. So about KTA Advocates, KTA, which was formerly known as Karuhanga Tabar and Associates, we are a specialized and recognized, internationally recognized law firm under the IFLR. And we are focusing on technology, media, telecommunications, intellectual property, and construction law. We advise our clients on so many areas, including financing, exploitation, and protection of such rights that we are discussing today. We are a team of 16 specialized lawyers, and we provide full legal services in different areas. So, of course, more will be shared about KTA, and you'll get to learn about us. More information is on our websites and the different social media. But akin to this clinic, we would like to share that KTA Advocates advised on the protection and registration of Janzi. You all know the Janzi music instrument with 2 scales that was invented as an improvement of the local Adungu musical instrument. Through this and more, our goal is to support the actualization of the treasure that we have in intellectual property. So about these clinics, the structure is very akin to a medical clinic. And like we've said, this is the first of its kind, and we are very, very proud of this innovation and the team that is behind this. Like we've said, it's very akin to a medical clinic. And what we're going to do here today is to consider the many common issues as has been observed in social media regarding copyright and intellectual property in general. And then we will come up with a diagnosis to see how can we work around these challenges. These will then be triaged with a focus on protection and commercialization of such copyrights under the hashtag @ButtersMyBread, with specific attention to using art as security for financial access through the Security in Movable Property Act 2019. One critical case to be discovered will be admitted for further attention, and the event will conclude with a discharge toolkit on the knowledge of copyright. How amazing is this? Our audience today, we have quite a number of people who have joined us on our Zoom, but we are also streaming live on Facebook. The live stream link has been shared on the comment box. So if you have other people who want to share, but they're unable to share on Zoom, kindly direct them to our Facebook link and the different social media pages where they can be able to join in and be part of this audience. But just to put our audience in context, we have selected a very, very advanced, or I can say very, very special panel of passionate Ugandans who jumped onto this boat the minute we mentioned to them the idea of having these clinics around intellectual property and specifically on copyrights. We have artists in our midst. We have officers from the Uganda Registration Bureau, SIMPO and IP, who are really the regulators in charge of ensuring that this, what we discuss really births action. Lawyers in the different intellectual fields, I salute you and thank you for joining us. And all people from the relevant areas in different fields in our society, we have ensured that we have everyone be part of this. The topics that we will discuss as shared by Bonita is that we're going to focus on us just understanding copyright in general and what is protectable. And then the big elephant in the room, how can I earn from my art? And I'm very excited to share this. Third, we will look at what is simple enforcement of those copyrights, and then different artists will share their different copyright experiences. Therefore, it is really, again, my utmost honor to open this session and just be able to welcome you all again on this Zoom. And please, we have ensured that everyone is catered to. If you have questions throughout the program, the inbox is available. Please share your questions, they'll be attended to. If there is specific information about this clinic that you would want to have, yes, we are available. And anything else as the sessions move on. I wish you a very good time with us today and tomorrow. We will still be here tomorrow, 9 a.m. to midday. So please log in. We look forward to sharing ourselves with you and also getting to know you. Thank you very much. Back to you, Bonita.
Thank you very much, Asmahani. You've just summarized the whole concept very well. Thank you so much for your opening remarks. To everyone out there, as Asmahani said, this is really the first of its kind, but it's an open conversation for us with the artists and all other people, especially in the creative industry, for them to learn how to earn from their copyright. As we say, the theme is commercialization of copyright. If you do tweet or talk about this event, do not forget to use the hashtag @ButchersMyBread. And also you can tag us on Twitter at KTA_law, on Facebook at KTA Advocates, and also KTA Advocates on LinkedIn. Thank you very much, Asmahani. The next event that we're going to have, oh, my apologies. I also remembered that I forgot to introduce myself. My name is Bonita Mlelenji. I practice law at KTA Advocates, and very specifically in the TMT and Intellectual Property Department. You're welcome. The next event that we're going to have is a discussion by one of our partners, which is really about the basics of what copyright is and what is protectable. As Asmahani stated, in as much as we have discovered that specifically being during the lockdown and the pandemic, that we are utilizing a lot of copyright or enjoying a lot of copyright, but how many of us do pay for the music? How many of us do pay to watch the movies that we are watching? How easy is it for you to download a song from a website that probably does not pay the artist in the end and then share it with everyone else on WhatsApp? It's very important for us to ensure that we pay the artists for their creations, because the journey of creating art is not cheap, and art should butter their bread. Art is a profession that people should be earning from. So it's not just something that we dive into once in a while and enjoy without having to pay for it. So without much further ado, the next item is about copyright, as I stated, and the presentation will be made by our partner, our managing partner at KTA Advocates, Mr. Kenneth Muhanji. Mr. Kenneth Muhanji is also a lecturer of intellectual property at Uganda Christian University. Mr. Kenneth Muhanji, you're welcome.
Bonita, many thanks for that. I think you forgot your other title. You're the head of the TMT practice at KTA. So please do not forget that very important point or piece of news. Good morning again, everyone. As introduced by Bonita, my name is Kenneth Muhanji. I am the managing partner at KTA, and I also am the partner that is in charge of the TMT and IP practice there. I also lecture intellectual property and so many other hats that I wear that are recorded in the presentation that you have in front of you. So I'm very blessed and honored, first of all, to be here. I'm very blessed and honored to be speaking to you this morning about the basics of copyright. And I know that we have a very diverse panel today. I've seen so many experts and I'm really looking forward to learning from them. And I've also seen so many listeners, so many attendees, and we're really looking forward to sharing what we know. And we hope that we're going to have a very interactive session where we're all able to learn and perhaps share what has been happening in the industry, what's been happening in the legal space, what's been happening anywhere where copyright is applicable. So I'll start, since I have 30 minutes to be able to take you through the basics of copyright and what is copyrightable. I hope, first of all, before I begin, that everyone is healthy. We are very cognizant of what's happening in the world and what's happening in Uganda today. We are all under lockdown, so I hope that wherever you are, you're healthy. And if you're not, if you have any loved ones that are not feeling well or that have or that you have lost, we commiserate with you, and truly we are all in this together. So I am speaking to you from my home as well, since we're all working from home. And we really hope that we'll be able to make the best out of the technology that we're using now, and especially since we're talking about copyright. All this is the technology that you're using on your phone and how you're able to view these things. This all falls under what we're talking about today. By using Zoom, by using WhatsApp, by using all these applications, you're all able to do that because of copyright. And that's what we're really going to talk about today. So I'll get right into it, really. If you're looking at, let me just put this on the side. Okay, there we go. So copyright is really the right that's granted to an individual to protect their skills. And when you're looking at copyright, if you break down copyright with the word itself, copyright, it's really, to use very, very simple terms, very simple English. It's really the right that any creative or anyone that creates any work has the right to be able to exploit that particular work. So when they use the word copy, by exploiting, really they mean that if you create an original work and put it in tangible form, that means any form that someone can be able to touch or to read or to hold and to see that really this is a particular work, then that work has copyright subsisting in it, in the sense that it can be copied several times over. And if it is copied all those times over, that copying is with the consent of the owner or of the creator or author. and that that author or creator is able to get money or to get some sort of compensation for it. But most importantly, okay, well, I think this is second, since we're talking about art butters my bread, the important thing is getting your compensation from it. So the other right that you get is the right to be associated with your work, the right to say that this work has been created by Mr. Ngovi, by Mr. Taibwa, and so on and so forth. That is what we call a moral right, and the right that that you have when you're making money from your creation is what we call an economic right. So the law that we have that governs copyright in Uganda is the Copyright and Neighboring Rights Act, which if you read it and you compare it to other laws all over the world and within East Africa as well, I think our lawmakers did a very good job. For all the things that we blame them for, surely the Copyright and Neighboring Rights Act is one that I think they did a good job, because it is comprehensive, and it even when it was passed back in 2006, we have seen that it has still applied in the digital age, because I think by that time we didn't have digital media as prevalent as it is today, and infringement perhaps was not as prevalent as well as it was by the time the act was passed. So the act defines copyright as a right granted to an individual to protect their skills and efforts in the production of original works such as literary, scientific, and artistic works. So I will be breaking down each of them. Copyright is a creation of intellectual property and is the property right subsisting in certain specific types of work as per the Copyright and Neighboring Rights Act. I think it's easier if you view the screen this way. So as I mentioned before, copyright will protect the fruits of creation. Creatives are you people that are here watching and listening. Creatives are people that are able to use their minds, their intellect, and what we call cognition. Cognition is really the ability for you to think and perceive. That is, if you're looking at philosophy, you're looking at psychology. So relating that to intellectual property or to copyright, if you are able to cognize, then you're also able to create as a result of that cognition, because your mind will put things together and you'll either create a song, you will either create a poem, you write a poem, you will record a movie that is based on a script that you have created or that you have written. So we shall look at all those different types, but basically copyright, or when you talk about creativity, it really denotes things that come from the mind. Well, maybe the other aspect that I can add, since most creatives also operate from the heart, perhaps we can add that one as well, that it operates from the heart and from the mind as well. So copyright protects the creativity in the choice and arrangement of words. I gave you examples of that. If you've written a book, the books that you have written, the words and the way they are arranged in the manner. If I was to pick any book from here, this is a recipe book that I have that has cooking recipes, mostly for Indian food, for those of you that love Indian food. So for such a book, the way that the recipes are arranged, the way that the words are arranged, this particular arrangement is what will get copyright protection. So you'll get copyright protection in exactly the way that it is arranged, and the whole book as a whole, the way that it is. And then if you're then looking at other aspects like musical notes as well, with music, you can break down music into very many parts. And I'm glad that we have artists and producers, artists like Isabel and David Taebwa, who produces from Opus Music. So those will basically take you into what goes into musical arrangements and what aspects of those are copyrightable. But basically, if you have a song, you'll notice that the first thing you're looking at, of course, before you have the song, is the lyrics of the song. That's if you have a song that has, where you have someone singing or someone portraying a particular message. So those lyrics themselves will get copyright protection, because if you have a song, usually you'll have very many people working on that particular song to produce the magic that will hit your ears and either get you dancing or take you, on a journey, depending on what the artist wants to be able to communicate. So those lyrics may be written by a person that's not the person singing, or that's not the person who has arranged the music. And in that particular instance, that copyright will subsist in those lyrics. Then you'll also have copyright that may subsist in the beat. That is the sound, the percussion that you hear, the melody basically. So that will also have copyright protection, and whoever has created that will either have separate intellectual property protection, copyright protection, or you'll all be joint authors or co-authors depending on your level of involvement with the work. And then you also have other aspects of the song, things like the arrangement, things like if you're also looking at the design, the artwork after the album is concluded. So there are people that are more that are experts in this, and I will allow them to be the ones to take you through all that. You can also be able to have protection over the choice of colors that you have used and how you have used them. If you see the presentation that you have there, you have bits of orange, you have bits of black and brown. So colors, of course, a color on its own cannot get protection because you can't get a monopoly over a color. This is because all of us will want to use these colors. So you can't say that you have copyright over a particular color. Copyright creates a monopoly over something, and you can't create a monopoly over something that is used by the public. So in that particular instance, if you do have colors that have been placed or arranged in a manner that is unique, and that copyright will subsist in exactly how you have arranged everything, not the color on its own, but how everything has been put either in a catalog format or in the way that the arrangement has been made. And then you also have shapes as well that, again, if you refer to the presentation, there you have arrows represented facing down. So that representation exactly the way it is, if someone copies it and another person is able to see, but this looks exactly like how Kenneth's presentation looked like, then that will most likely be infringement. And perhaps something that I need to stress is that copyright protects the expression of an idea rather than the idea. For many people, and there are very many questions I get about this, especially if you're looking at people pitching like for shows. I know we have a couple of actors and movie producers that are listening in. So in those instances, if you come up with an idea and you want to pitch that idea to someone, you want to go and pitch it to David Taebwa from Opus for asking for his help to be able to promote your show or to be able to get you sponsors. So if you have that idea in your mind, if you say that, I've come up with an idea for a show where someone is going to sit in their house and they're going to talk about copyright all day long, that is an idea because another person elsewhere will also have the same idea. So you cannot really have monopoly over the idea. However, if you put that idea down into a script or into a reduced format, then that particular idea has then become expressed. And the way that you have put it down, if another person copies it exactly the way you have put it down, and if in particular they also have access to where your original work is, then you will also have, then you may have, or you will have a cause of action for copyright infringement. So that's what we say, also, that's what we mean when we say that copyright protects the expression of the idea rather than the idea. On that part, maybe I'll also add that a little advice I'll also give to anyone that may be in such a predicament, where it may also be, impossible for you to do that, especially if you have an idea and it may be impossible for you to reduce everything down the way that you may want to. You may also take advantage of the law of confidence, where you sign a non-disclosure agreement, or you'll inform whoever you're speaking to that I am giving you this or pitching to you this idea. I do understand that it's an idea, but it is a novel idea, and I don't want you to disclose whatever I am going to tell you with anyone else. So there you may not get copyright protection, but you'll get protection under what we call the law of confidence, where you may not even need to sign a non-disclosure agreement, because that may also be impractical in the circumstances, although I must stress that you have to sign it. But just in case you're not, if you have that communication with the person verbally or orally, that will also suffice, and you will be able to get protection under the law of confidence. But we can perhaps be able to discuss that a little bit more if there are any people that have questions about that. And then copyright gives the author exclusive rights to control whatever they have created. That is in terms of publishing it, that is in terms of distributing copies, performing it publicly, or broadcasting it on Facebook, broadcasting it on TV stations, or anywhere else where the author feels they will be able to get recognition. So under Section 2 of our Copyright and Neighboring Rights Act, an author, the person who creates the work, is the one who gets protection over the work that they have created. However, you also have Section 5 that talks about someone who has employed a person who has created the work. So I'll use an example of design. If I commission someone to create for me a design, or to design for me a cover, either album cover or book cover, whatever design that I have asked, or even these shirts, if I create someone to commission to design for me this shirt the way it has KTA here, then I become an author as well under the law. That's under Section 5, because I have commissioned someone to create this work for me on my behalf. I may not be as creative as the person who is creating for me. So in essence, I am paying the person to create the work on my behalf, and I become an author. And we are going to look at a case, I think it's the George William Kakoma case, where the author there, the late Kakoma, was commissioned to create the national anthem, and that also then created other issues later. We shall look at that case. But someone who is commissioned or employed to create a work becomes an author. And once you become an author or an owner, you then have the right to license, to assign, to sell anything within the work itself. So that particular copyright that you get becomes your property. It becomes your title. If you're relating it like to land, with land, when you purchase land, when you purchase a car, they give you a logbook. When you purchase land, you have a certificate of title, and so on and so forth. Now, that title is the one that asserts or affirms or confirms that it is you who owns that particular property or that particular material that you're claiming a right over. So with copyright, they also give you a certificate of registration, and that becomes your title. However, when you have that particular title, you can also be able to split it. And if you want to sell it, then you transfer the title the way you transfer any other property. You assign all your rights in it. It's what we call assignment, which has to be in writing. So anytime you're giving anyone intellectual property, the law says that you must assign in writing. So you can't give someone copyright without doing it, without putting it down in written form. Number two, you can also be able to license aspects of your work. What a license means, a license is basically a temporary right to be able to use a particular work, either for a specific period or for a specific purpose. So if I create a song, for example, I can be able to license, if I create the song and the song is going to hit the airwaves. I mentioned there's an artist already who is Isabel, and there's a song that she sang called Wuyu. So if that song is supposed to be listened to on radio, and if then she wants to be able to license it to a water company, let's say Purifier, for them to be able to market their water, then she will license the rights to that song to Purifier, and Purifier will then be the one that will be able to use the tune or the song to market whatever products they have, but only for that purpose. They won't own the song. They'll just own the right to use it for that specific purpose. And the license can either be either be granted to one person exclusively, where no one else can be able to use that particular song for that period within which it is licensed, or it can be non-exclusive in the sense that Purifier can use it, Renzori can use it, or any other company can be able to use it. What matters is what you contract. And that's why with contract, you cannot discuss copyright without discussing contract or freedom of contract. People enter into these contractual relations without any duress. And when you do so, whatever you agree or whatever you want to apply will apply based on what you have agreed. If you have what we call a meeting of the minds, or for those of you interested in Latin, consensus ad idem. So as I mentioned, I think I already told you it is a right to commercially exploit the work, so we shall move on from that. So the types of copyright today, I've already been mentioning these as I am moving along, but we have what we call literary works. These are works of literature, for those of you that are interested in literature. So these may include novels, short stories, poetic works, and lectures. I lecture in intellectual property at UCU. I've seen a couple of my students there, and I also lecture with Kajobi Brian, who's going to be speaking to you today. Very, very eloquent man. So for those lectures that he has created, or those lectures that he has put down with his knowledge or with his creativity, then those are also subject to intellectual property protection. This presentation that I'm giving to you now, you are not allowed to share it without my consent, because I have put in my skill to be able to create it, although this particular one was created with my team. So that is what we call, or those are what we call literary works. Then you also have musical works and sound recordings. These ones I'd already explained. This can be songs, this can be arrangements, this can be soundtracks, really anything that is recorded in a tangible form and that has what we call a phonetic output, or something that will be able, like something in using simple English, something that will make someone dance or shake, if you're talking about music in that sense, then that is something that will have copyright subsisting in it. You also have pictures, graphics, and sculpture works. There's a sculpture just right behind me there. If you can see it, that would also get intellectual property protection. And if I can also, use a painting like this. This is a painting that would also be able to get intellectual property protection, because it has also been created as a result of creativity. And then you also have graphics design. The graphics that you're seeing for the copyright workshop were created by a company called Elevate. And so although they were commissioned, so KTA is the one that owns that, but copyright subsists in those particular works. And then you also have dramatic works. These are works of theater, or if you're talking about plays and the rest, shows like Sanyu that many of you watch. You have motion pictures and other audio-visual works. These are films and movies. You have pantomimes and choreography. These are aspects of dancing. And many of you that have watched shows like America's Best Dance Crew, I think there was also one on NTV. I forget. I don't recall the name of that. But that choreography, those arrangements, the way that they're done, they also have elements of creativity, and those also get intellectual property protection. And lastly as well, and this is perhaps something that many of us may not know, but architecture works as well can get copyright protection. If you have a unique building, like the Uganda Mata Shrine in Mugongo, it's a unique building, the way that the building has been created or the way that the building was designed. So those designs get intellectual property protection or copyright protection. And in the past, we used the UK Designs Act to be able to protect such architecture drawings, but now they fall within the ambit of the Copyright and Neighboring Rights Act. So copyright does not include ideas. I already mentioned them. If you have an idea, something that's that is just purely in your mind, it will probably not get IP protection. Procedures. These are ways of, if you're saying, if you create SOPs, like our government has created SOPs for us to be able to get through this period of COVID. Such particular procedures or means, if you're looking at mathematics, if you're looking at those equations and the like, those cannot be able to get copyright protection because they are used by everyone in the public. So this list of the things that are here usually either used by the public, and so should not be able to get a monopoly. They believe either they are not creative enough or do not have that creative input to be able to get copyright protection, or perhaps they are too short. If you're looking at what we call the de minimis principle, that is for names, titles, and short phrases, those will not be able to get copyright protection as well. So others are systems, methods, concepts, discoveries, scientific discoveries. For those of you that are interested in that, the Planck constant, if you're looking at the Dirac equation, if you're looking at the Big Bang theory, and things like those are discoveries about how the universe works or about how the world works. And those really explain things that will benefit the public. So you may not be able to get copyright protection in things like those. Of course, facts as well. A fact is a fact. You cannot have a monopoly over a fact. And then public benefit works. These are works that will help the public, do not also get copyright protection. So as I mentioned, the law that governs the act that governs copyright in Uganda is the Copyright Act. We also have the 1995 Constitution that provides for the right to property and for the right for you to enjoy your property well. Since IP is property, since copyright is property, that law also applies. So the Constitution is a supreme law in Uganda, and it protects you in the same way the Copyright Act will also be able to protect you. So copyright may also be used as a way to protect the wealth of a society. If you're looking at culture and cultural expressions, I think if you're looking at the history of Uganda, we were colonized by the British. But before that, we had societies, we had laws, we had customs that applied. And when these guys came, of course, many of those things were lost, and then we took on other cultures and customs. So copyright is also a way to help people to protect or to preserve their cultural heritage. I showed you the art there. This I actually got from Ghana, and it shows it really, the art there has different drawings. I see a lion, and there's also a bird called a sankofi, which is a bird used to remind them not to forget their cultural history. So you can see this is a very simple and small art piece, but it holds within it the art or knowledge of a particular culture or a particular group of people. So copyright is that important. And for each of your cultures, especially within the context of Uganda, I am a Unyankole, and we have particular artifacts that we have that keep our culture, or that are able to show other people, other generations, that this is something that has subsisted from the beginning, from depending on how you believe you came to be onto this earth. But whoever was the first person that was in Uganda, up to now, that culture can still be recorded either in art, in literature, or in any of the forms that I have mentioned before, and copyright exists to be able to protect that for time immemorial. So if you are looking at what it takes to obtain copyright protection, as I mentioned, that work must have been created independently, in the sense that it must be a creation of your mind. I added as well of your heart, depending on where you draw your inspiration from. And it must have at least a minimal amount of creativity. That one really is one that would say a reasonable man would be able to answer what is a minimal amount of creativity. There's what we call a test of a reasonable man in law, which is someone who is an ordinary Ugandan in this case, in this sense. And there's a Court of Appeal case where Justice Kakuru defined a reasonable man in Uganda as one who listens to radio, has children in school, either rides a motorcycle or a bicycle to work, and has a mobile phone. So for that particular person, can they be able to say that this is actually creative? And if they can, then that may most likely be able to get copyright protection. It must also be fixed in a tangible manner. I've showed you that either in on canvas, if you're looking at an art piece, in a book, if you are looking at a book, or even in a phone, if you're looking at sound recordings or anything of the sort. So it has to be in a tangible medium where you can be able to hear it, to see it. And it also does not need to be permanent, really. You can be able to draw something on a napkin, and that can still be able to get intellectual property protection. Or you can also be able to draw something somewhere, and then perhaps you take a photograph of it, and it's either washed away by the rain or something of the sort. So that also is handled on a case-by-case basis, depending, because if we talk about it, does not need to be permanent, but the consideration there, it does not also have to be short or transitory, in the sense that if you create it within seconds, it cannot, there's always debate as to whether people that design food, for example, will get copyright in how, in how they design, like for those of you that have gone to Java's or any of these coffee shops, and how they really put those hats for you on top. Can that get copyright protection? I cannot answer that clearly now, but I would say that since that is temporary, or impermanent, it may not be able to suffice or get copyright protection. But if you took a photo of it, then we'd be discussing something else, because the photo is one that will subsist longer than what was in your cup. Then at what stage can the works be copyrightable? This is as soon as the work is fixed in that tangible form, then it gets copyright protection. Is there any time limitation? Copyright usually will give you a right over your work for your lifetime. So you don't need to register again for your lifetime, and also 50 years after your death. So the example I like to use, unfortunately, is the late radio that passed on a couple of years ago. His music, we're still listening to it now and we're still dancing to it. But that copyright in that work will subsist up to 50 years after his death. So his family or his estate is the one that would then be able to enforce his copyright until such time as that copyright stops to subsist. But there are also ways to be able to extend that period, and companies like Walt Disney or the like have been able to tweak parts of that design or parts of that work to be able to create a new work that has a new lifeline of its own. So those are all ways or tools that a creative can be able to use to extend the period of their work. And then the other limitations, of course, are that once you have the exclusive right, you can be able to perform it in public, to broadcast the work, to communicate it over any media, either the phone, social media, or anything of the sort, and to make copies of it anywhere that you go. There's also the right of a co-author. This is something I'd mentioned. If you have a song where you have 2 or 3 people creating it, I know I have a few more minutes, so I'm just going to really speed through this, unless there are questions that, so that we can have room for questions later, and for the presenters as well take you through this. So a co-author's right is where a work is created by 1 or more people. So here we're looking at 2 people and more. Once you have that work, for those of you that use music streaming platforms, if you go to Apple Music, Spotify, Tidal, any of those particular applications, usually if you tap the lyrics as the song is playing, at the end you'll see song written by, and you usually see very many authors that have co-authored the song or that have produced the song. So a co-author's right shows that all those have the same rights in the song, or if they have different rights, those rights are established. And that's why it's important for you to sign agreements if you're going to create works with other people. Sign an agreement, my people. Sign an agreement. It helps you to avoid any arguments over what part of a song or what part of a work someone has created. The moral right is one I'd already mentioned before. This is a right to be attributed to your work. And this right, by the way, is unalienable in the sense that even when you give away your economic right, the right to make money from your song or from your work, the right to be identified as an author, original author of that work cannot be assigned. At all times, they will know that it is Kenneth that created this work, but assigned it to this person and this person. So that is something that if you have a contract that says that they have taken away your right to be identified as the person who created that work, that is illegal or void ab initio, and that contract cannot be enforced under our law. So I've already told you about the duration of the copyright. I won't really go into that. I already explained to you about the creativity and what and who creatives are in that particular instance. So I wanted to just briefly tell you about the Kakoma case. This is where this guy had composed the national anthem, of course, as you know, but he had done it through a competition. But the challenge was there was nothing written at the time. But we know under Section 5 that if you commission a particular work, then that work belongs to the commissioner. And that's really what court held in this particular instance. But because copyright has to subsist in writing, the judge at the time, because the Copyright Act was not in effect at the time, mentioned that there were dual rights that are subsisted. There was a right in equity for the person who had created the work, being Kakoma, and the right in law being the right that had been commissioned by government, because it's the one that had commissioned. But because that transfer was not done in writing, that assignment was not done in writing, then that's why the judge had looked at it that way by saying you have an equitable and a legal right. Unfortunately, that particular mind was changed at the Court of Appeal, although I still strongly feel that if you have a right that has not been assigned in writing, then you cannot say you have a legal right. Because if the law is clear, and the Copyright Act is very clear on that any assignment has to be in writing, then you cannot assign something verbally and expect that assignment to be confirmed as one that has effect in law the way it was meant to be under the Copyright Act. So the other case is, if you're looking at technology, Google versus Oracle. This was a case that was looking at whether you can be able to copyright open source software. Open source software is one that is used by developers or by anyone really to be able to either create more things or to allow people to access a particular piece of content. So an example of open source software is one like for MTN, for mobile money. Since we use mobile money to make several payments, MTN created an API that allows you to, if you create a website where you want to be able to receive mobile money, you connect through that API, and then you will be able to utilize MTN's online platforms or software for you to be able to make or receive payments online. Now, such open source software, if it is in the public, the first case said that in that particular instance, if you are a commercial entity as well, and you use that open source software without credit to where you've gotten it from, or without giving money to where you've gotten it from, then that is wrong. However, on appeal, that was since changed, and ultimately, they now say that copyright existed in that software, whether it is open source, that if it is open source software, someone can be able to use it. And they looked at fair use. This is where you can use something without infringing, even without the consent of the person who has created it. If it was created, it says that the purpose and character of the use, the amount and substantiality of the copyrighted material, the market effect of the copyright taking, and this one is actually repeated. So basically what they're saying is, if an open source software is created for that purpose, open source, it doesn't matter if it's Google, if it is Bing, if it is Yahoo that uses it, if you have marketed it as open source, then all those people can be able to use it without having to come back to you, if anything of the sort. So I have run out of time. I'll really stop there, but I'll just say that in sum, the justification for copyright protection is for it to be a fair reward for your work. If you have expended your mind to be able to create something, then you deserve a reward and effort for that work. And if you are compensated for it as well, even if you assign that work, you still also have a right to be attributed to that work, so that at all times they know that Chino Chavudde Kuono, that is the person who has created that work. And that's why we say, that's why we have the term moral right. Thank you very much.
Thank you very much, Kenneth. Unfortunately, you were sharing your screen and we were not able to see all the artifacts you were showing us.
Oh, I am so sorry about that. I had, this is the painting that I had shown you to talk about the graphic representation and the form. As you can see, this artist actually tried to use kente cloth here on the design. So by using this, they may not have copyright over the cloth itself, but the way they have used it here, this will get copyright protection. And then I had also showed you a book. This is a recipe book that I like for Indian recipes. I really like Indian food. So the way that the words are arranged in the book, the way that they are, this will also get copyright protection subsisting in it. And then the last is the artifact that I showed you behind there. That is a mask from Ghana, and that can also be used. That I was explaining it to show that a culture can be able to put all their culture in that particular work. I'm also seeing a question, perhaps Bonita, if you'll allow me just to say the same, can derivative work be protected? Yes, it can be protected as copyright, but I will hand over to you. I don't know if we do a Q&A now or later.
Thank you, Kenneth. There are a couple of questions that I will read out to you, or if you may read out from the chat. There's a question from Elijah Kasuja.
Okay, I'm seeing, can I copyright a shape? No, at the moment, the shapes are protected under what we call the Industrial Designs Act, which allows you to have a monopoly over a particular shape. So this is a shape here. This is of a bunny, and it may be a bunny that all of us know, but the way it has been created or presented, this will be able to get what we call industrial design protection. So shapes are now protected under our Industrial Designs Act, but in the past you could be able to maneuver and find a way to put that under our Copyright Act. But I would say clearly use the Industrial Designs Act for that. But may I just answer the questions as they are?
Yes, please.
Okay. Is attribution of copy to its owner sufficient protection against an infringement? Yes. If someone has asserted right over a particular piece of work, then once you have that right, copyright by nature does not need to be registered. It is what we call inherent. So what that means is that you can be able to enforce copyright even without having it registered, as long as you have proof that you're the first one who created it. But that is a very difficult thing to do because we share experiences and we share history. You find that the idea I have come up with and I have expressed is one that my brother or cousin or someone else has also come up with. So the best way to be protected and ensure that one person gets protection over another is if you take it to URSB and register and get a copyright certificate. And we have officers from URSB that are going to take you through that. That's why it's important to register your copyright. I think the last question is, can derivative work, no, the more questions, can derivative work be protected as copyright? Yes. A derivative work is one that's formed from an already existing work. If I create a book and then I want to translate that book, for example, from English into Luganda, you can get copyright in that new work, but you can only get copyright in it if you get consent from the author who has created the original book. As we said, copyright gives you a monopoly and a right for you to exploit that work. So anyone that wants to create a derivative work has to do so with your consent. A right can still subsist, but that right cannot or may not be enforceable. And if they take you to court, they can cancel whatever right you have in that particular work. Can a performance or idea generated and shared in live stream be protected? That's a good one. There's a case by the late Lord Mayor Sebagala, where he was recorded after he had come from vetting from Parliament, and the recording was funny to many people, and many, in particular SMS media, used it with MTN to be able to record caller tunes. So Sebagala tried to enforce copyright, but the court held, and that is the position of the law now, you cannot get copyright protection over work that is random or work that you have not prepared. If you don't have a script, or if you haven't prepared that particular work, then you don't have copyright protection over it. So things like speeches, things like performances that are, that are not either, that have no script or haven't been prepared, you may not be able to get copyright protection over them. But if you show that you are reading from a script or that you had prepared something where you are basically getting structure, then perhaps then you may be able to enforce. But that case is a very good case to read on that. How do I emphasize copyright over gospel music and drama works? As I mentioned, go to URSB and protect it. If you have that song, you can reduce it. You can print out the lyrics, or you can be able to put that song on a CD or whatever format it is, and you take it to URSB. URSB will take you through exactly how to do that practically. But you have to get a certificate over that if you want to emphasize the copyright, because your question was, how do I give emphasis? So as I said, copyright is inherent, does not need to be registered, but if you want to enforce it, you have to take it to URSB and get that certificate. Then I have a question concerning YouTube videos. Let's say I have content up on my Twitter and it goes viral. However, it's uploaded onto YouTube by another person and it goes viral there. Can I get remunerated entirely or partly because I didn't upload it myself? When you create a work, you have a monopoly or right over that particular work. Now, if it's a YouTube content also has copyright protection. Vloggers also have protection. There are very many popular sites now. I think She Tracy is one where people, and then you also have the one with Raymond Kahuma and the like. I think those are the ones that are really popular. The one of Uncle Mo as well. So that content has copyright protection. And if someone posts it and is making money from that post, then they are supposed to pay the person who has created it. However, if they're just sharing it and it goes viral, if you're sharing it on your personal page, then you can't have a claim there. That goes to the fair use. Someone is using it within the manner it was intended. You have already put it up online. So you have removed that expectation of privacy, or that you have removed any expectation that someone should not be able to share your work. So it's only if someone makes money from it, like if you see your content, your YouTube video that you have created, and then you see MTN or Rezori using it in one of their adverts, there you have a claim and you can be able to sue whoever has used it. What happens if, but there are so many questions, I don't know if we still have time. You'll be able to guide because there are more questions coming in. Maybe I'll just answer this.
We'll take 3 more questions and then we'll go to the next item.
Okay, so what happens where a big musician registers stolen music from an upcoming artist who never registered the same? This is a very good one, and this actually happens a lot. And that was the mind or reason why we created this particular workshop. Bonita was the brains behind it, and that's why really, as Mahani already mentioned, that APAS posted and said, you know, don't steal my music. So in this particular instance, it doesn't matter if it's a big musician or a small musician. As long as you have your song reduced into either you have the lyrics or you have the song itself, you have produced it, and someone uses it, the beat or anything of the sort, then you have a right to claim for money from that person. Give me compensation for using my work. It doesn't matter which artist it is. Don't fear anyone. You can be able to go to court, and court will be able to listen to you the way that you are. So your question shouldn't even have big musician or small musician. No. And if that musician registers the stolen music, as you have mentioned it, I'm using the words that you have mentioned, then you can go to court, or you can actually go to URSB itself, to the registry, the IP registry. There are procedures where you can ask them to expunge or to remove the song from the copyright register. But also, when you're registering copyright, there is a period, I think, of 60 days where you advertise, you inform the public in the Gazette that this is my work, and anyone in the public that feels that this is their work as well can inform URSB, do not register copyright in that work, it doesn't belong to that person. So if you miss that step, usually that advert is in a Gazette, and URSB has now given us a Gazette that we can use cheaply, and that I think will also get wider circulation. If you can't get it from there, you can also, so those ones are called object, you can object to that registration. If you can't do that, you can also be able to file a suit later to cancel that copyright. Or if you can't do that as well, you can also be able to go to court, and court will listen to you and give you that. So I'm just going to answer the 2 more questions. So can performances recorded by artists or DJs be protected? Yes. Can't I get copyright for a meme with my face in it, even if I did create it based on what you've said? That's a good one. If you're looking at your face, then you're going into the realm of what we call image rights. Image rights are the right for you to use your identity or your likeness. If someone thinks I look good, then, and they use my face somewhere, or if someone thinks I look funny and they use my face somewhere and they make money from that, then they are supposed to pay me for my likeness. And so many people have actually sued. I've seen very many celebrities who have sued. Maybe we can have a separate discussion on the right to publicity and the image rights. Bonita, you'll guide on when we'll have it, because I think it's a very important aspect of copyright that we need to discuss. The slides are ready with you. Bonita will be able to share them after. I think Bonita, there are 2 other questions, but I don't know if other questions will come in. So I really leave it to you. You told me to answer 3 questions, but there are 2 other questions that are unanswered.
Unfortunately, we have to keep time, but we can take those questions, and we'll have, if there is more time at the end of this, we'll have them answered. If not, we can carry them forward to tomorrow. And regarding image rights, Brian Kajabi is going to speak to us about that on his panel session, which is going to be later on this morning. Thank you very much, Kenneth. We've had what Kenneth has told us about copyright, what it is protectable, what you can get and also your rights from copyright. But the focus of this discussion is that you should earn from your creation. Art butters my bread. You should be able to make money from your creativity. Like we've said, the journey to creating these things, these songs, to writing, to even going in that mind space. I know, especially for writers, to be able to write a piece of work that we will love, that we will read, especially during this pandemic. You should be able to earn from that. But that is also linked to registration of copyright, whereas it's inherent and you may not need to register it. Registering it gives you an added advantage that you have evidence, it's documented that you are either the first person to write this down and you obtain rights over it. So it's easier for you to have evidence for which you can present in court when you have to make an argument. But also specifically, registration would enable you, tomorrow we'll discuss about the Security in Movable Properties Act, and URSB will be talking to us about that department, that registry, for you to be able to use your music as collateral to get financial services from banks and other financial institutions or microfinance institutions. A practitioner of IP that I know called Grace Nakavugo, who works at Max, is always saying you should think about intellectual property, or now specifically copyright, as the way you would think about a car, the way you would think about land. It gives you, it creates its property, its copyright and its intellectual property. It creates property for you, which is something, a creation of your mind, the ingenuity of your mind, which creates the property that you own and should be able to earn from. So for you to be able to access that, registration is one of the ways that would make it so easy for you to through simple, it's called simple security movable properties. It's called simple, for you to be able to access that financial service. I think one time, and Pato Ranking, I think he sent out a tweet where he made shares available to people to buy rights, to buy shares rather, in a particular either song or album of his. This should be the norm, that it's not only or always land or a car or something that we can touch and feel. There are things that we do not see, but they are property, and copyright is one of those things. At this moment, we'll take a break for 15 minutes for you to be able to get a cup of tea or coffee and stretch a bit. And when we return, we'll have an official from URSB talking to us about how we can go about registering copyright. So see you all in 15 minutes. Enjoy the break. Hello, everyone. We are back for our second part of the session. And we are very privileged to have Sarah Rukundo, who is the Senior Registration Officer, Intellectual Property Department at Uganda Registration Services Bureau. She's going to tell us about the procedure to get copyright registered. Ms. Sarah Rukundo, kindly take it away.
Thank you, Bonita. I hope everyone can hear me clearly.
Yes, we can.
Okay, thank you. I'm going to share my presentation. So my presentation is going to be strictly on registration, since Kenneth has already covered the other aspects of copyright. So I'm going to go straight to registration. Perhaps the only thing I could mention, which I had prepared to mention to the participants, is the work that is protected in Uganda. Many people tend to ask if I use foreign works, do I still have am I still infringing? So I wanted to highlight the fact that all work created by a citizen of Uganda or a person resident in Uganda is protected in Uganda. Work first published in Uganda, irrespective of nationality or residence of the author, is also protected. Then work created by a person who is a national or resident of a country, which is a member of WIPO, ARIPO, UNESCO, the World Trade Organization, and the signatory to the TRIPS agreement, all that work is protected, and even work which is first published in those countries. So as you can see, that our Copyright Act gives protection for a very wide range of works. So I want the participants to know that even foreign works, which are used here, if they're being used without authorization from the relevant right holders, there is infringement that is going on. So the rest of the issues were covered by Kenneth. Duration of protection was covered. So let me go now to registration. As Kenneth already mentioned, copyright is protected automatically when the work is created and in material form. Registration is, however, important because it assists in keeping evidence of ownership of the right, identification of the works and the authors, and maintenance of records. Like Kenneth had said, we are moving into an era where copyright can be used as collateral in banks, where copyright can be used to acquire other assets. So in that regard, it is prudent that a copyright owner is registered so that they can easily identify their right and the extent of it. In that regard, the law provides for registration of copyright and neighboring rights, assignments and transfers of copyright, and then copyright licenses. So when it comes to registration of copyright and neighboring rights, you just need an application in Form 1. Copyright registration is via a single form, and it is on our website, and it is easy to fill. So once you fill this Form 1, you have to get a deposit consisting of copies or records representing the work for which registration is applied. Whether the work is published or unpublished, you can have a record of it, and so you need it to attach it to your application form. This can be a printed copy of the work or an electronically stored copy of the work. You also need a non-refundable application fee of 50,000. This is assessed via the URA portal. Kindly hold on a bit. I need to speak to my colleagues to reduce the noise. Thank you. Please, I'm making a presentation. Thank you. Okay. So the contents of the application for registration of copyright are listed in the regulations, but they are summarized in the Form 1. So once you have filled the Form 1 correctly, you'll have already provided all the content that the registrar needs in order to process your application. So this is the process for registration. The application is received and given a number and a date. After receiving it, the registrar evaluates it and issues a notice of publication in the Uganda Gazette. Copyright is still published in the Uganda Gazette. It's only trademarks that have moved to the URSB journal by virtue of the Trademark Amendment Regulations of 2021. But copyright is still being published in the Uganda Gazette. When after the registrar issues a Gazette notice, the applicant will pay the publication fee at the Uganda Gazette. These fees are assessed and paid at UPPC, and the application will be published in the Gazette for 60 days. And if there is no objection received to the registration within 60 days from the date of the advertisement in the Gazette, the applicant will deliver a copy of the Gazette where he advertised his application, and a certificate of registration will be issued. At this stage, there are no further fees that are collected at URSB for issuing a certificate. So the total fees for registration of copyright is 50,000, the fees that are payable at URSB. So when it comes to assignments and transfers, if you want to register an assignment, let's say someone has assigned to you or transferred to you their work, you apply in copyright form 4 and attach the instrument, that is the assignment or transfer agreement by which you have become entitled to the work. If you don't have an assignment agreement or a transfer agreement, you attach a statutory declaration setting out the full particulars of facts upon which you have a claim to that work. You have to have an application fee of 50,000. The registrar will evaluate your application and then issue you a certificate of registration for that assignment. When it comes to licenses, the application for registration of a license is in Form 6. The fees are 200,000. The license application should state the full particulars of the instrument, if any, under which the interest is claimed. By instrument, we mean again license agreement, or license contract, which you have to attach to your application. Then you have to have a statutory declaration of the owner stating the relationship between the owner and the licensee, and it has to specifically state whether the license is general or specific, whether it is for a limited period of time or not, whether it is exclusive or non-exclusive. The registrar will evaluate your application once it is received and will issue a certificate of registration. So the practical steps to applying or sending your application to the registrar: obtain the forms. They are on our website and they are free of charge. Fill the forms and pay the fees. Then scan the forms together with the receipts and send to ip@ursb.go.ug. The office will receive your application and then advise you to deliver a copy of your work to the office where applicable. Like I said, you can have it printed, you can have it on CD, or you can even send an electronic copy to the registrar. All the works that we receive here at URSB are already protected because all URSB employees, by virtue of their employment contracts, supposed to keep information confidential. So you shouldn't worry that the registrar will get your work and use it in a way that is not appropriate, or sell it or do something to it. That is not allowed. So once you send us your work, we use it and put it on record as your work. And the reason for this deposit is because in case of a conflict in future pertaining to your work, the work is good. The work that you have deposited at the office is the work which is going to be used, for example, to determine whether someone has copied your work or whether someone has stolen your work or done some other type of infringement to your work. So once we receive your application, like I already mentioned, we evaluate it and process it, and you will get a registration certificate. Copyright is registered once, and there is no need to renew registration. So once you have registered, it is registered for your lifetime, and then 50 years after your death, if it is copyright. And as you can see, this is a long time. So this registration can also help your successors in title to know that you actually had this work and to have proof of ownership that this work is part of your estate. I think that is all from me. Thank you. Bonita, I think I'm done. Excuse me, Bonita. Bonita, I need to confirm if you can hear me because it appears that there are some people who could not hear me.
Yes, sir. Thank you. I was having trouble being unmuted.
Okay.
I dropped off on the call, unstable internet. But I heard you. I do not know how many other people did not hear you.
Okay, thank you. Someone has confirmed that they could hear me. There is a question. Someone is asking approximately how much is paid at UPPC. It is between 400,000 and 500,000, I think, at the moment. Do I have to pay 50,000? No, if it is an album and it has a single title, you apply for it as one work, as one album. So you pay 50,000 for the entire album. Also, if you have several albums and you apply for each of them, we give you what we call a single gazette notice. So we can give you a gazette notice with several works. If they are works of the same category, for example, it's all music or it's all books or it's all movies, so that you have one single gazette notice, because we are aware of how much it is charged to publish your application at UPPC. So we can give you one single gazette, so that will reduce the amount you will pay in publication fees. But that applies only to works that are in the same category belonging to the same author. And the applications must have been filed at the same time. Computer programs, yes, computer programs are considered literary works, although they have also a scientific side, but they are protected under copyright. So once you apply for protection of your software, we expect you to deposit your source code either on CD or in some other format in which you may feel free to deposit it. But yes, you can apply for your computer software and have it registered. If you register copyright in another country, is it impossible in Uganda? Yes, like I had already mentioned, there are very many countries protected under the Ugandan law. The Ugandan law protects works from very many other countries, countries that are members of the World Intellectual Property Organization, members of the World Trade Organization, members of the African Regional Intellectual Property Organization, and all signatories to the TRIPS agreement. And those are quite many. It's very hard to find a country where someone can say, I am not protected, my copyright can't be protected in Uganda. So most of the works, as long as they are still, they are not in public domain, are protected in Uganda. Registering your catalog of songs at the same time. I think this for these kinds of scenarios, it is best if you come to the office and inquire from us, and we look at your catalog, and we look at the amount of work you have to register. Also, we look at the times when the agreements and the licenses were signed, and then we advise you accordingly. For games and someone is asking about an Android game. For games, yes, we protect games. They are also protected. We register games, sorry. They are also protected under the Act, as long as the game is original, like Kenneth had already explained, as long as the game is original and meets all the criteria for works of authorship that are protected under the Act, we register it. Juanita, I think those are the questions. Maybe if there is another question I may have skipped. I saw a hand up earlier. Someone had their hand up. If you still have a question, you can put your hand up again, and then I'll let you ask your question. Thank you.
Thank you very much, Sarah. I saw it was Andrew with his hand up. I don't know if he's still on, Andrew. Do you still need the question answered, or it's been answered?
Okay, I think maybe the question was answered, Bonita.
I think so.
Yeah, for all the works that we register, as long as you have a title of your work, you have a deposit of your work. If it's a computer program, if it's software, you have your source code and you deposit it with us, then that's how you can apply for your copyright. So basically you need the application form, your work, the fees, and that is all at URSB.
Thank you very much, Sarah. I am hoping that we've all benefited and had your presentation. We are very honored that you came to join us today, and we thank you for your presentation. I'm looking forward to you receiving many more applications from artists in respect of copyright. Thank you very much.
You're welcome.
The next item we're going to have is a panel discussion that is going to be chaired by our Judith Kagere. The topic is our trending hashtag, which is @ButtersMyBread. This panel is going to explore how to earn from your creation under copyright, the basics of the relevant contracts, and relations to enable commercialization of art. As previously promised, we'll also have a discussion on image rights. I'm looking forward to that. Brian Kajibi will be taking us through that. But for now, inviting the chairperson of the panel, who will then invite the panelists, is Judith Kagere, who is an IP practitioner and an associate at KTA Advocates. She is under the TMT and IP department and also the corporate and commercial department. Judith, you're welcome.
Hello, hi Bonita. Very generous this introduction to our panel. Our panel is going to be discussing @ButtersMyBread. So we're just going to be talking about what is unregisterable, how can I, so this panel @ButtersMyBread has 4 immensely gifted men, and they're going to just tell us works, because as a creative, you do not just want your works to be able to give you the moral benefit or just having the satisfaction. So I'll have the pleasure of introducing an immensely gifted poet. He's also a performer, and he's an author of for poetry books. He works at KTA Nation, which is a Ugandan poetry company, and he's also the founding editor of the KTA Nation poetry series. Then he's a screenwriter, a producer, Ronnie. He's an alumni of the Mnet Screenwriters from 2009, the Maisha Film Lab in 2008 and 2009. And he's was also nominated at the Owaga Film in 2020. Samuel is also a gifted director. He has directed a short film, and it was also officially selected at the 40th Durban International Film Festival. And so we can't wait to hear more from him about how you can be able to protect your works as in the film and in the film industry and in the movies industry. Then we also have David, who is a corporate administrator. He has a background in management, music administration, and he's also a music tutor. Then lastly, and also importantly, we have Brian Kadribi. He's a lawyer. He's an associate at Nangwala Resida. He's an IP litigator and practitioner. He's also a lecturer of business. He's a member of the ULS IP. Peter, you're online?
Yes, I am, Judith. I'm online.
Hello, how are you?
I am well. How are you?
Well, thanks. So I think I'm going to just shoot you the first question, and then maybe we can direct the discussion towards. Tell us generally, how do you commercialize your copyright protected material? How do you, as an artist, as a poet, how do you make money?
There are various ways that literature is consumed by people. It can be consumed as a readership experience. There are those people who access our works through books. And so we have author and publisher contracts that ensure that these relationships are lined out well, and the benefits and responsibilities are spelled out well. There are people who consume our literature through performance. Say, I could be invited to perform somewhere, or someone else could be invited to perform somewhere and they want to perform my works. Or someone wants to use my poem as a score in a movie or a song or a documentary. They reach out. And then to the extent, then the academic world as well, some teachers and researchers want to use our works to inform their own creativities, and that way they reach out, and if they're going to use the work, of course, and there are monetary benefits attached to the works, that way they have to reward us, the original creators of those works, and then we give them permission to do so. But then also there are other adaptable forms, for example, especially with merchandising. Say, for example, if I write a poem that has a popular line, and there's a clothing company that wants to create a brand of wear that features my works, all my imaging, then that way, of course, there are also those negotiations that we get into, and that's how we manage to benefit. And then there are those that create apps that want to distribute our works differently. And that way, either online or in physical shops, and that's how they reach out, really. Thank you, Judith.
Thanks, Peter. I think maybe you can give us a little more light on how do you, as an artist, arrive at a fair reward for your effort? How do you get to realize that this is a fair sum, maybe that I'm entering into a contractual negotiation? How do you negotiate for you to know that this is how I value my value?
Okay, now, personally, of course, definitely the first point, the first point to look at is how much time did it take you to create that piece of work? I have a poem that took me 6 years to create. And if someone is going to ask me to want to present it, of course, the charge is going to be determined by how much time it took me to create it. And then there is also the question of how much investment, especially financial investment, has gone into the production of that particular product. Again, it varies. How much do you spend on producing a book, creating a book? How much do you spend on creating poetry videos or poetry albums? How much does it take for you to buy the produce that you're going to use to adapt the works into the other products like bags or t-shirts or whatever? So that comes into play. Then the third one is to know how much are the people that are going to use your works. How much are they going to benefit from it? I think last year someone called me and they wanted to use one of my poems to perform at the Black History Month in the US, and they had been hired by some organization to know that, and so it's suddenly different when someone says, I want to perform your poem for a social cause on the streets. So it also depends on where your work is going to be used. It also what matters is for how long is your work going to be, for how long is your copyright, for how long is your copyright going to be assigned to that person for that particular use? If an online magazine gets in touch with me and wants to publish 5 of my poems or in their journal, the copyright is going to it's going to be accessible to to their readership for a period of 3 years, vis-a-vis it being available for a period of 3 months. That also comes into play. And then the other is to know how much you are worth as an artist. To know how much value you attach to your own product. As Kagai, I invest in retreats, to go and write. I invest in workshops. I invest in online lessons to improve on my creative writing process. I buy books. So all those are costs that personally I would have to compute to be able to determine how much my work is worth. Thank you.
That's very, very interesting, Peter. Interesting. I think I can channel the discussion to David and Samuel. David, maybe you can go first. What's your experience from the side of film and publishing about scaling your copyright? How do you commercialize your copyright in your respective industries?
Do you want me to go first or do you want David?
Yes.
Let David go first.
Thanks.
Is it me or is it that I can't hear David?
I cannot hear him either.
Okay, maybe I could go so that we don't keep the session.
Yeah, I think Samuel, you can go and you can just jot in when you're in the middle of your conversation.
Yes.
Sorry.
Yeah, thank you, everyone. It's a pleasure to be here. I'm excited, and and the discussion has been interesting. And I was just listening to Kagai talk about his monetization options, and I realized that they are not so dissimilar in a way that everything's sort of structured, and also with the advent of electronic technology that we have more opportunities. So there is like a hierarchy of rights, for example, the traditional route. So you have cinematic or theatrical rights, which are basically your cinema. Then you have broadcast, which is your TV, which is paid or free to air. And then you have streaming services, streaming rights. So you can, that covers sort of like online distribution, whether you put it on a free service like YouTube, or you put it on a social media website, or you go for like a Netflix or a Showmax, or in our case, a Kiasi TV. Then you have an option to sell your content to airlines. You have like the in-flight library, in-flight entertainment, your movies. You've seen those films on those flights to wherever. It doesn't, like long haul flights. Then you have library rights, where someone. Yeah, my house is literally by the road, so you may hear a lot of that. So you also have library rights, where someone wants to put your film or your piece of content in as part of their catalog, so people can watch it when they come to see things. And I'm not talking about libraries in the case of, like, say, Punchline or your regular, or it could also be rental libraries, which is also a thing. Then you have institutions like universities or schools who want to screen your film whenever. I used to work for One Fine Day Films, and regularly would have people call us and tell us, or send us an email and tell us they want to screen the film, and we give them a screening fee and things like that. But there are also things like territorial rights. Okay, so I've explained all the avenues where you can monetize, but there are also territorial rights, where you have a situation of holding the rights for Uganda or Kenya or East Africa or Africa or the world, so you can sell rights to different regions, say North America or Europe or Southeast Asia and things like that, or you can sell them as a whole. For example, with Netflix, you have to sell your rights everywhere, but that's a total discussion about that, rights, like selling rights for your content. The other thing that also works for filmmakers that may not have been explored actively is, it's sort of like how you have sync rights for music, where you can put a portion of your song on the soundtrack. You can also have a clip of your film played, say, on a screen in the character's TV, that's playing along when they're watching your film. So that's also an opportunity. It's just that we've not monetized that. And that actually just came to me because my TV is on and I just thought about it. Yeah, that's it for now. I can hand it over to David if he's back on. Thank you.
Okay.
We lost you for a second, but you're back. So
can you hear me now?
Dive in. Yeah.
Okay. So I said I was pleased to see everybody, every participant here. We are so humbled that you've attended. I'm David Tayewa, and I'm a music administrator, also an expert in copyright management and collection management, specifically for the music industry. There are many ways, everybody has talked about how we can monetize, commercialize our creations. But me as a music administrator, I feel we've skipped some line. One of them is registrations. Yes, it's important. You can't really commercialize your music unless somebody knows you out there that you're the eligible owner of such a copyright. And this all goes through how metadata is managed. Metadata is that little information you provide to when you're releasing, let's say, music, a music work, yeah? Who wrote the song, who produced the beat, who performed the song, who financed the making of the sound recording. Such information is important in that if you just release your music outside there without attaching such metadata, your works, the revenue that comes from your works get lost from what we call a black box. Many of the times you say, yeah, we are going to monetize. I know how I can do that. I can distribute the music everywhere. But then what really happens is that the money doesn't locate you back where you are. I think it's an important phase of first monetizing. Then we can look at all these other markets available. I'll talk for the music industry. As a music publisher, of course, I look at music as a product. And there are many ways I can monetize my music. One of them is what we call song plugging. If I'm a songwriter, I can write a song to another artist to perform it. Let's say Yese Oman Rafiki, and I've sold a song called Moses Amarwa to Bebe Cool to perform it. That does not mean that I've assigned him my copyright, but it's a way of giving out a license. I'm licensing you to perform that song to the public as a creator. Yes. Then, secondly, we can look at synchronization. And synchronization means music can be synchronized in many ways. If you can put it in a moving picture or a video, that means there are many opportunities music to feature in a film, in a commercial advert, in a documentary, or even in a video game. I've seen some video game creators here. Yeah, you need to reach us up to have a license to put in some music in your games. Yes. Then thirdly is what we call performing rights revenues. Performing rights revenues uh, uh, are mostly about where does your music play. Yes. One of them is that your music can be played on radios, on televisions, in clubs, in restaurants, in gyms, at airport lounges, and everything. But there is a taxing body, I could call it taxing or collecting body in every other country that is in charge of collecting revenues from businesses that use music to make money. Yes, so a good example is that in Uganda we have what we call UPRS, Uganda Performing Rights Society. It's one of those bodies that helps us as creators to actually generate money when radios play our music, when TVs play our music, when bars play our music, when gyms use our music, and everything. So there is that revenue that UPRS always has to give us as creators when such music is used. Then fourth and last one is what we call the mechanical rights revenue, which takes in streaming, music downloading, and physical record sales. Yes, you've been knowing that now physical record sales, selling music on CDs and flash discs, um, is kind of scaling down. But in Uganda, you never know. We still have people that consume our music through such medium. Downloading is of course brought up by internet and streaming. We can now generate more revenues by people going to Spotify, people going to YouTube and listening to our music. So we have deals with the guys that we call digital service providers, who actually, when we put our music, they actually in turn give us revenue for the people that have streamed that music, or they have downloaded the music. We share revenue. But also another way, like for YouTube, is that YouTube uses our content to attach adverts. Remember, when you are going to watch a music video on YouTube, sometimes you first watch an advert. So YouTube also pays us through that system. We share the advert revenue. So that is just a major way how we can commercialize our music. But there are many ways. Right now, there's something that is coming up where you can actually publicly trade your music or your copyrights to the public and you actually get a funding. I will take an example. Kenzo wants to release an album, let's say in December. He can come up and talk to his fans, the making of the next album. There's 100 million, 100 million will carry production. It also cater for promotion. That means, in that sense, he's awarding the consumers of the music. And I think that is where our industry should be now going to, awarding the people that listen to our music. So if such fans can have shares in the albums, then it means, one, you've funded the creator who has had some advance before they've made the music, but also you award the consumer, the fan, because if that music is outside there and it is being streamed, it is being put into movies, and it is being downloaded, or some money is coming from UPRS, it means now you can share such revenue, the royalties, to the fans, and that actually increases, it increases the dynamism in the industry. Many people will now be engaged, interested in promoting more of the songs because they know they are going to earn in the last sense. If I promote more, I will get more capital growth because I've invested in Eddie Kenzo's music. So that is all I can say, how to monetize music. Over to you, Judith.
Thank you, David. I think that was interesting to understand it and see it from your point of view and everything that's happening in your industry. I think now we can hear just a bit from Brian before we jump into the questions to be able to connect into the discussion. Brian, could you tell us more about the how do you help clients, or how do you help cooks?
Thank you very much. Judith, kindly, can you repeat your question? I lost you. Your network was not clear. I kindly beg.
Oh, pardon me, Brian. I was asking, as a practitioner, how do you help creators to be able to, from the legal side?
Okay. I had the first bit of it. How do I enable artists protect their work? The last bit, I didn't get them. Thank you very much. Good morning, everyone, fellow panelists and those attending. I take this opportunity to thank the organizers of this clinic and for inviting me to share a few insights. How do you hope these artists to protect, more so to realize commercial benefits from their work? I hope members can hear me. My fellow panelists and the rest of the members attending, there are things I wish to highlight on before I even share my thoughts about how can an artist or a musician enjoy protection and later benefit. You see, you can't learn the music business by going to a class, watching a video alone, but it's better by experiencing it and also learning from those who have been there. Now, as an artist, if you're there, I'm told I will try as human as possible to simplify these concepts to avoid the legalism, because the main stakeholders here are the artists who are in the arts industry. Now, as an artist, are you building a career or a hub? Because those two will give you direction. Do you just want to continue singing, just singing, or there is something you're targeting in addition to singing or performing? I have heard stories. I think the common statement in Uganda since last year when COVID started has been, there are two. One, we don't have copyright law in Uganda. That statement was made by a good number of artists. They make that statement probably because they are ignorant about the existence of the copyright law. The second statement has been, for those who know that we have the copyright law in Uganda, the artists have been saying that we have a very poor copyright law. Those statements have featured predominantly since COVID started, but you sympathize with the artists simply because it is the environment within which their work is created that pushes them to make such statements. First of all, I wish to clarify this. If artists are here, Uganda has one of the best copyright laws on the continent. It goes without saying that it's one thing to have that law, it's another thing to benefit from it. Just like they say, sleeping in a garage does not make you to be a car. So whereas you have that good law, how do you? So one thing I should emphasize that every time you hear copyright law, the law does not give you money. The law does not bring food on your table. No, the law will say you're entitled to A. But you keep on saying, when am I getting my A? No, you need to be very pragmatic, assertive, and above all, professional. So once you are professional in the way you handle your creatives, in the way you handle your content, I can guarantee you'll make as much money without even wondering whether we have the copyright law or not. So, Madam Moderator, let me just highlight a few things. If your business is in the media or creative industry space for the artists, it is important to understand, for example, who owns the copyright in each piece of work that is produced by you or whoever you've given permission, and how it can be exploited or commercialized to advance your commercial interests. Now, here is the problem why most of our artists or musicians have failed to reach to a level of benefiting or exploiting their work commercially. This takes me to the difference between a musician and an artist. Once you understand those two, you will know how to benefit. Why? Many musicians think that they are artists, and many artists, they are artists, but they remain at the level of a musician. By simple definition, an artist, when you have an artist or a musician, those two are used interchangeably by many people. They think they are the same, but they're different. What I can emphasize is that a musician is anyone who plays a musical instrument, sings, performs, or creates music. Then on the other hand, an artist is anyone, whether a musician or not, who creates or contributes to music creation. In other words, a musician can be an artist, but not all artists are musicians. What I'm trying to say is that I can be this person who will play or who will perform a song composed or created by Bonita. I just go in a bar, what we normally call miming. I just go and do that. Or Bonita can write a song, compose a song, give it to me. I proceed to the studio. I engage the producer. I go to the publishing company. The video is done. Bonita, who has written the song, and myself, whereas she will enjoy different copyright in the works she has come up with, we don't fall in the same category. One is a musician, another is an artist. So when you're an artist, it comes more with a professional level, the way you see an amateur footballer and a professional footballer. If I play soccer in my village, even if I score 100 goals, how can I translate those 100 goals into the commercial exploitation? But if I go to a professional level, then perhaps if I score those 100 goals, there is a value attached to it, then I will be known. Before you know it, everyone will be using my name. So the point I'm trying to make here is that professionalism in the way you do your work, your content, will now help those who are going to help you protect and commercialize your work. So it's quite important to highlight that. Now let me go to the gist, how ordinarily you help musicians or artists. And I will emphasize artists. Why? Artist is not only a musician, a person who helps in creating. This is where you will find any other person. It may not be only in the music. And I wanted this discussion to benefit even people who are in any other creative industry, but is related to entertainment. You can think of comedians. I wake up one day, I create my work, I upload it on YouTube. Before you know it, a certain TV station has contacted me. Can we have you on one of our shows every day? So I'm a creator of content. I'm in the arts industry. Though we used to think that artists were those limited to drawings, paintings. No, now it is a broader thing. Now, this is how it is done. Normally, before you engage an artist, if they want to commercialize their business, there are 2 or 3 things you advise on. An artist must have a manager. The reason for that is that an artist, normally you get excited. When you get excited, when it comes to commercializing these things, deals, David has talked about synchronizing, you're going to perform, you'll be excited by the money on the contract. But there are clauses, I'll see later, that will tie you, whereby you lose, or even the record label or the other company, let it be endorsement, let me say telecommunication company, as you've licensed something, and before you know it, you cannot perform on another concert organized by a competitor. But you didn't read that clause. I think you remember it happened to the late radio when they were in Still Good Life. They signed a contract, then later they performed at a concert of a competitor. It's not that they were selfish, that they wanted money. These are simple basics. Looking at the details in the contract. So normally you, the artist, you may not be that exposed to look at these other boring clauses. Your manager can engage a lawyer. So the first thing, before you think of commercialization, get a manager. However good you are, you must have a manager. Why? A manager will do these other things you are not able to do. For example, a manager will do door-to-door marketing, will market his artist, will look for banks, will look for radio stations, etc. So you wouldn't want to be seen. You're the same person pushing for your music here and here, radio stations, company trying to look for endorsements. At the same time, you're supposed to be in the studio. So that is the purpose of a manager. Also, the importance of a manager. The manager will help you to create a brand, a personal brand. You know, there's a difference between your music, then there's that brand you have. You have a brand of Bebe Cool, but there's Sally, Jose Chameleon, but there's Joseph Mayanja. So a person will have to associate with the brand. That brand can be created by the nature of and the quality of your music, but also a manager plays a very big role. Also, A manager will help you to groom you professionally. Why? You are not going to endorse a deal to be the NSSF ambassador, however good your music is, when your character, when your interpersonal skills are wanting. You're always seen in a bar fighting, you're always on YouTube insulting people. No serious brand would wish to associate. So without going into the legalese, there's that business and professional aspect whereby before you help an artist, there are those things that must be in place. Do you have a manager? A manager plays a very big role. Then the other thing, as I summarized, probably, I don't want to take a lot of time, we need to consider is when these artists, in most cases, approach if most cases when they're approached by big companies that deal in several things, most artists, like I said in the beginning, they get excited or overtaken by the money. So how would I help an artist? I'll look at the following things. Your goal. Of course, definitely your goal is to make money, right? You've already made the name. So at that stage, I will take you now to the component of the contracts. I'll tell you that the nature of your work, because in Uganda, what is important is not, what is important under the law is that for as long as you've created your work, it doesn't matter whether it is a nice song or not. But that's what the law says. Like I told you, the law does not give you money. The law will say, you don't need to register your work. You don't need to register your song. Your song, even if you just cough and you go in this by looking at the serious clauses. At a later stage, I wasn't given time limits within which I should. But at a later stage, I will share. There are several contracts an artist can engage in. We have pre-musical contracts and post-musical contracts. Pre-musical contracts, this is where the artist, before they create their content, it may not be, sorry to use the word musical, but it may not be only music. It can be you're a comedian, you're a YouTube content creator. So before I create my song, or before I go to the studio and all that, there are those contracts you enter into before creation of the work. These include management contracts. Management contract, that's where you get a manager. So when you are before you're signing that management contract, you need to pay attention to several clauses. Is the manager going to own your brand, your image rights, your personality rights? 2, are you going to be signed to this person till you die? There must be a way out. I won't go into the details for now. The other type of contract, pre-creation contract, is a production agreement. Production agreement, this is where you have Bonita who has composed the lyrics, has come up with the lyrics. I want to sing the song. I've discussed with her. Now I go to Mr. Swang's Avenue. I enter the studio of Swang's Avenue. I enter into an agreement with Swang's Avenue on how this song is going to be produced and who are the stakeholders. Now, in such agreements, production agreements, there's what we call the split sheet clause, where I think someone mentioned about it. Most new artists, when a song becomes a hit, there's always a problem on how they share the royalties. You find that a composer is entitled to royalties, a producer is entitled to something, and other people who are involved in the creation. You remember the first definition that I told you? An artist is one who contributes to the creation of the musical work, not only the person who sings. So a producer is also an artist. A video and audio producer is also an artist. So with that, the split sheet clause will create a demarcation. Who is entitled? Who is entitled to what? If you don't have that in your production agreement, I can guarantee you those are the things you have where producers are fighting with artists. Record labels fighting with the artists. You remember what happened to Lil Wayne, whereby they told him, don't do this until. So production agreement is also a pre-creation agreement. Then we have the post. where you've already created the work. So after creating, then you look at how do I benefit? Now that is where there is bread and butter of the artist. Because in pre-creation, you might agree, in the future, if this and this happens. But remember, post, the work might have a unique value compared to what was anticipated. You know, we've seen that song. I'll give an example of this song of Eddie Kenzo. The one that made him get that award, getting the title. When it was starting, the people didn't pay in attention even to the lyrics. But the production of the work, you know, there are many songs whereby the lyrics, the composition, it is average. But when you listen to the beats or even when you watch the video, so certain things market, you may find the song or the musical work, the entire song, you look at one component which can make a song a hit. It can be probably the title or the chorus, but other things are nothing. Or it is synonymous with what the common society is talking about, Chiguarero, you know, those kind of things. So that is an example of a post-creation. But normally, what you negotiate in pre might be even lower, but it is in percentages. You don't envisage that this work will win these artist awards. Now, most producers, most managers, record labels, of course, record labels never get involved in such battles. But if I'm a single or solo artist, I don't have a manager, I walk into a production company, I'm excited, they give me little money. Later, my song is nominated in Mama Awards. I'm getting massive endorsements. You realize that some people will just ask a lawyer, man, this song, I participated in creating it. Don't you think I'm entitled to something? The lawyer will just say, you are. You call the artist, no, Biagwa, let me enjoy my money. Before you know it, they will slap you with a legal suit. So the point I'm trying to make is that normally post-creation, that is where there's bread and butter. You need to be extra careful when you are negotiating that deal. There are several clauses I wouldn't want to go into at this stage, probably until permitted. Then the other contract, after creation of the work, we have the general endorsement deals, where you enter into a contract in a beverage company just to do something. Then you have broadcasting contracts. Now, here, like I told you, an artist, every time you create work and you realize that there are many people whose survival is dependent on your work, you need to become professional. If you're there and whatever you do is capable of employing many people, even if they are two, then it means that any mistake on your work or the way you do it, it will have a bearing on other people. Now, that is what comes to artists. Artists don't know that their work, there are many people who survive on their work, either knowingly or unknown, either directly or indirectly. I can survive on your work when you don't know, probably I'm infringing on it. But I've seen in Uganda, it is only in Uganda, where an artist prides in his work being infringed. It is only in Uganda. Do you know why? My fellow panelists will agree with me. It is the environment. We grew up dissing artists. If you're Muyimbi, Oli Mudongo, you're Muyaye, you're always in a bar. They try to see, your parents try to see you are taking the line of music, like, you're going to be a Muyaye. Now, our setup, our minds have been tuned to a level that every person who comes up with creative work, especially in the music industry, dramatic work, you were Muyaye, you were failure. Because of that, they kept on disrespecting the creatives of your minds. Hence, that's why artists, they do what I will call a sacrilegious sin. They go to a media house, they make payments for their work to be paid. Where do you find that? It is only in Uganda where an artist will pride in their work being infringed. Your song will circulate on several media houses. Someone is using it on YouTube, and you say, he's promoting me. I'm a celeb. How? But it's because of the mindset. One, an artist prides in showbiz for as long as I'm popular. That popularity cannot help you in a situation like COVID. It will never. So those who were smart, they knew that I am Silver Kyagulanyi. Don't tell me that you're going to just play my music. Can you sit down? This is the value of my work. How much are you paying me? Please, I have given you permission. Go ahead. So the mindset. That's why after that, in 2010, you are saying, no, I am popular. Play my music on YouTube, radio. 2019 and 2020 plus 2021. What are you saying? Uganda has no copyright law, or we have poor copyright law. It's because, one, you fail to follow the principles of an artist. Have a manager. Number two, know the basics of how to engage in professional music. Stop being an amateur. So to that extent, next time you see someone playing your creative work, be it your comedian, you created your work, there's a platform where you share it, and someone else is purporting to commercialize out of that, hey, you go for them. Ringtones, good to go. So with broadcasting, most artists forget that when I'm engaging you, I will ask, a promoter will come, a media house will come. So you have Silver Kyagulanyi or Eddie Kenzo has a concert. Now, Eddie Kenzo will sell his concert to a promoter at 50 M. Now, most musicians or artists, they look at the money. There are things you can guide an artist on, that there is more beyond money. For example, I can get, Eddie Kenzo, you can get 50 M from Balam to buy your concert, meaning that he will get collections. Your role is to appear and perform. But are you aware that there is another type of money or kind of money you can get other than that gotten directly from Balam, the promoter? So that one is determined by agreement. For example, if other companies are going to advertise alongside your concert, you have, let me say, name them. Who is going to take that money? Has Balam as a promoter bought your rights, all your rights, absolute rights in the concert, or he has only bought perform? Whoever's come to watch you, they pay the money. I pick from the goat collections. Or once I've bought the rights, should there be Belaga, Uganda Breweries, Hamukola, name them, they want to associate, brand association with your concert. Does Balam take that money, or that money should go to you? Now, those are the basics they don't consider. Then before you know it, I'm told Balam, you received 100 M from MTN. Yet I already gave you 50 M. Now you hear they fight. So when it comes to broadcasting, you have a concert as an artist. Then there's another TV station that is broadcasting your show live, not news. You see, they can come and take pictures, just brief clips. Then they go and do what we call news bites. They have their shows. But the question here is, you are performing in Serena. There's a TV station broadcasting your performance live. Do you know what a Ugandan artist will say? I'm a celebrity. They are promoting me. Now that is the mindset. So you need to know also it comes to broadcasting rights. Why? Later, that show can be rebroadcasted, or it can be sold to another person. And when it comes to broadcasting, whoever broadcasts has the copyright in the broadcasting. But that person has to get a license to broadcast your concert. So normally a promoter gets that money. Once a promoter buys your rights, will tell you, I'm taking everything. Your role is come, stand here, perform. I'll give you 10 M. On the day you step on the stage, I'll add you another 5. You perform 8 songs, I add you another 5, etc. They negotiate those things. Broadcasting, NTV will come and say, oh, this is a concert, people are in lockdown, we're giving you 100 M. The guy will take 100 M. No other TV should broadcast that event live other than NTV. So when NTV is broadcasting, then there are other commercial benefits NTV gets from broadcasting. How? They will say that if this musician, let me say, Coca-Cola will come, say, we want to advertise during this concert. So NTV will make more money. While you're there, you realize that many companies were advertising during the live concert with NTV. You get wind of it that NTV made 800M from broadcasting your live concert. Why? Many people were home. This was an opportunity. The next thing you say, I want my money. No. You made a mistake. You didn't negotiate your deal. The promoter was smart, took away those rights, later sold them to the broadcasting company. Also negotiate that should any other person associate with this show, like adverts, can we get some percentage royalties? So these details are quite important to an artist than merely looking at a one-off payment, which is dangerous. You get your 50M, you see a promoter getting 800M, then you say, this should have been the fortune of my life, and would have quit music. So there are quite other things we can look at. The other thing I can talk about is an aspect to do with the record label agreements.
Hey, Brian, I just wanted to cut you short just right there, because we're just running out of time. We just have 5 more minutes, and I wanted to just get a word in from Samuel. I saw his hand up.
Thank you, Brian. You said quite a lot of things, and I saw a comment in the chat about we need to take cognizance of the reality of the industry. I understand that everything you say is how it should be, and we are working towards that, I believe. And the legal fraternity will be quite critical in helping us achieve this. In terms of management and contracting and all that, I will tell you, as an artist, I think that it is very difficult for people to understand the complexities of, licensing and contracts, and generally the nitty-gritty of rights monetization and all that. And I think one of the things that we're lacking as artists is that capability, not as individuals, but as we need professionals who are dedicated to entertainment law. And we don't have entertainment lawyers in this country. At least I've not come across them. I've come across IP lawyers, which is one thing, but entertainment law is a totally different ballgame, which encompasses a lot of things, which you mentioned. And I agree that these things are necessary. As an artist, I think I'm privileged that I had a chance to study contract law in my ACCA studies, but I can tell you, majority, and I'll put my hand there and I'll tell you 90% of artists do not have any interest in administrative work when it comes to their creativity. They just want to create and put their work out there and express themselves. So that's one thing, but I'm glad that you've mentioned it. The need for it is very critical. The other thing I wanted to pick up on was David's, and this is the last thing I'll say, David's mention about shares in creative works. And I think KTA had a session on non-fungible tokens. It's a new concept. And I think, I might be wrong, but I think I saw something on the LinkedIn for KTA that non-fungible tokens are kind of like what David Taiwa mentioned about getting shares in someone's work. And I think crowdfunding is one way in which people can own partly a work. And I think it's a very viable approach to financing for creative work. So that's one thing. And I think we could talk about all these things for each of these sections could be a masterclass or a panel on its own. So I'll just stop there, given time that we don't have. Thank you.
Thank you, Samuel. I think we can just get one word in from David. There's a question about these mushrooming music associations and collecting royalties. Maybe you can tell us.
Oh, yes. Thanks everybody for your contributions. I see now we are a team of good experts. Thanks to you, Brian. Thanks to you, Samuel. Yeah, and thanks to you, Judith. So the issue of mushrooming music associations, most of the time I've had a problem with it, and it comes from the love for money or handouts. Every other person right now is trying to place themselves somewhere to be dear to the government, because some time back I heard that it was being um, the government was giving some money to the entertainment industry, to the CCI, that is creative and culture industry. So with all that buzz, now everybody wants to place themselves as an association to get some money. I think of that. But if you understand the background of music associations in Uganda, well, it's all about advocacy and the need to, eat something somewhere. Or if you need to move your agenda, make some pressure group and then push for it. Yeah, so we've had many, but of course I see some genuine ones. I wouldn't want to mention some names, but Uganda Musicians Association had reached somewhere. We have even some associations that have been formed. Look at the Uganda Music Publishers
Oh,
Association.
David, I just have to
Look at
cut you short.
Uganda Songwriters Association. Yes. All right. All right. Yes. So
Just have to cut you short because you're running out of time.
that's
This is the last.
okay. Okay. Yes, so that's specifically what I can say about associations. For my parting shot, I would like to look at CMOs. Somebody raised the question about UPRS and how they don't trust it. Of course, things are taking a turn right now, and I think they're in the rebranding process to actually change the whole system. I would say I'm just like a general consultant there, especially in collective management. And I think the toll we are taking is the right one. You should just trust UPRS. One, it has the monopoly. It's the only, registered and licensed music collecting society. So you have to go with that. We only have to enter in and change it from within, but we don't have to fight it. Yes. Thank you, Judith.
Thank you, David. I think over to you, Bonita.
Thank you very much. Excuse me. Thank you all very much for this session. I have personally learned a lot, and it has struck a huge debate that I can see going on in the comments. Unfortunately, we do not have sufficient time to go through each and every comment, but I'm very appreciative to you, the panelists, for sharing what you know. And before we close, I just want to recap what has been discussed today in no particular order. We have learned about copyright, what it is, what is protectable under copyright. We've also heard about the advantages of registration of copyright. We have also delved into the need to analyze contracts that artists sign. And we went a little bit into the details of the different contracts, which include broadcasting contracts, management contracts, pre-creation contracts, post-creation contracts, where the emphasis was that this is where, that is the bread and butter. Then you have endorsement, particularly on contracts. If you have the opportunity to visit the KTA website, you will find our concept note. And this was one of the key challenges that we highlighted. I think there are people, especially maybe people of my generation, for the longest time, people would ask and say, why haven't we had a song from Jojo? You know, the only song we ever knew for the longest time was Too Little Too Late. And then a documentary came out and we learned what was going on. She got into a contract with a record label, and they had ironclad clauses in them that she couldn't come out of. But also, if you visit Netflix, there's a documentary about a gentleman called Machado, who also lost the right to even use his name, because when he signed the contract, he did not see that thin line, or he did not read in between the spaces to see that he was also signing away his right, the rights to his name. So he could not go and perform and say, for example, my name is Bonita Mlelenji. That is not a name I can go by to perform anymore. So critical for artists is to make sure that when they sign whatever contract they're signing, is to look at that contract critically. But as Kajuri said, it would be good for you to get a manager, so the manager can then look for this entire team of lawyers and other consultants to help you understand your contract and to protect you specifically. We also had about valuing yourself as an artist, so you can attach a price to your works, and then being innovative. Someone talked about NFTs. NFTs, non-fungible tokens, are the new thing, which is also something that David hinted on. Artists selling or creating shares so that people or their fans can buy, can invest in, and that will help them invest, and that will help them in the creation of their albums. That is something that you can do. So to learn more about NFTs, you can visit the KTA website. There's a writing about that, and also our social media platforms, but also you can look it up generally on the internet and YouTube and learn about NFTs. To re-echo, copyright does not protect the idea, but it protects the expression of the idea. It's not just enough for you to dream of have an idea. You have to actually graphically, or to put it down in writing, or execute this idea and represent it. And to that extent, Kajuri emphasized that copyright law does not give you the money, but it's a step to you getting the money. Tomorrow we'll discuss about enforcement of copyright, and you will understand how the law is there to protect you, yes, but it does not give you the money. But it's also your advantage to register your copyright, as Sarah explained. And tomorrow we'll discuss how you can use your copyright as collateral to be able to obtain financial products from financial institutions. The biggest challenges that were highlighted were the artists understanding the legalities involved in the contracts, but also understanding each nitty-gritty that is involved along the creation of art in the different sectors there are. We also learned that we need to build an entertainment, we need to build entertainment law, and specifically have entertainment lawyers. I think, as Samuel put it, most of the lawyers are really intellectual property lawyers, not specifically entertainment lawyers. I know of one entertainment lawyer in Uganda. He's called Louis Mwanga. But that is a highlighted challenge that we should consider. So I've seen some other comments in the chats and questions. And just to re-echo, the purpose was for us to understand what copyright is, to start this conversation, to start these discussions. And as Samuel put it, maybe we can have different masterclasses so that people can understand. It's very good for you to know, then you can protect yourself. If you do not know, then you will not know how to protect yourself. If you do not invest in being better at your art, or invest in having a team that supports you to be able to collect your money, or if you're not part of a collective society, as David put it, it may be difficult for you to realize some of these things. A lot has been discussed. Thank you all for coming and participating in this event. We have another one tomorrow, which will be the last one. And for tomorrow, we'll be looking at enforcement of copyright. We'll have Dr. Kakoza leading us in that particular one. We'll also have a panel discussion on where artists will share their experiences with copyright. For that panel discussion, we shall have Isabel. We shall have P-Funk Majani, who is the CEO of Bongo Records. We shall have Juma Immaculate, who's an IP practitioner and artist from Kenya. We'll have Sewa Sewa, who is also the owner of the Janzi. And we'll have a session from URSP in respect of the security in movable properties registry. Thank you again. I'm looking forward to seeing you tomorrow. Have a good day. Bye.